Okay, let's get right to this. What is the P.O.R. system through the Social Security Administration? If you go to GN044, sorry, 44434's 0.110, again, 04440.110, you get under the Program Operation Manual Systems POMS book the probability of reversal in quality review process. So basically, POR, I'm going to give you the exact SSA definition. That way there's no confusion. Of course, the SSA definition will be a little shitty. I'll then give some commentary on it. Here we go. POR. POR is an administrative tool used by federal quality reviewers when a case does not contain complete medical or vocational documentation as required by the Social Security Administration, which is it's a lot of gray area on that one, for a lot of wiggle room, disability program policy, federal quality reviewers must decide whether obtaining additional documentation is likely to reverse the disability determination or change the length of the period of disability. Federal quality reviewers cannot consider or apply POR to decisional deficiencies. Okay, let me read it to you again and then give you commentary, because again, the SSA definitions are always like, what is that? Wow, I don't, it's tough. And let's go. All right. POR is an administrative tool used by federal quality reviewers. It's a program inside a computer used by reviewers to do analysis of basically what's in the file. When a case does not contain complete medical or vocational documentation, this program searches through the system and notices that there's not enough medical documentation, there's not enough work documentation in the file. Puts up a red flag. Red flag gets waving all over the place, as required by the Social Security Administration Disability Program policy. So it's already got pre-designed parameters to figure out when there's not enough medical or work-related evidence in the file. Federal quality reviewers, people who wear special clothing and hats. I'm kidding. It's just SSA employees with that role. They're in that function. They review claims. Although it would be cool if they did have special clothing. And I'm talking like full on, they wear special suits that are all one color. It's a cotton affair. Very nice. A little bit of silk right here. Something nice. All right. Federal quality reviewers must decide whether obtaining additional documentation is likely to reverse the disability determination or change the length of the period of disability. So if you were denied benefits, it could potentially put it into an approval. If you were approved benefits, it could potentially put it into a denial, okay? Or it could change if you were approved for a certain amount of time, back pay before you filed, retroactive benefits. So you file, before that is retroactive benefits, after that is back pay. It's where it could change the amount of time in which they gave you that back pay and retroactive benefits. Cool. All right. Federal quality reviewers cannot consider or apply POR to decisional deficiencies. So remember, decisional deficiencies can be, that can be a lot of things, but think of those more as like there was a lack of something that they needed, that the adjudication you know what, actually, hold on, let me get the exact, because I want to get the exact SSA definition on that, because that's something where I want to be right on with you guys so that nobody is confused on that. All right, so let's go through this. Okay. All right. Social Security Administration defines decisional deficiencies. They occur when a disability determination is incorrect, even though the case is fully documented. Okay. So in other words, okay, so remember there's group 1 and group 2. So in other words, what happens is there's all the stuff there, but they F up. They get something wrong about the facts. They get something wrong about the law. They get something wrong where they collected something that maybe wasn't relevant to the claim, and they used it as part of the adjudication. They get it wrong, but the file was totally full and complete. So this is not the program used for full and complete files. This is the program used when the file is missing medical or work-related evidence. All right. For additional information, so okay, but there's there's two types of groups. We're not going to go through those because it's going to take too much time. But there's group one, decisional deficiencies, and group two deficiencies. Okay, let's skip through that. A federal quality reviewer uses the P.O.R. process as described in subsection D to determine whether either of the following exists in a case: non-substantive deficiency, which is a technical corrective action, or substantive deficiency, which talks about group one or group two documentation deficiencies. All right, I'm going to go through that in a minute. We're getting deep on it, but let me go through who makes P.O.R. determinations, some of the basic stuff. That way you've got a more broad and full understanding as to how this actually works, okay? All right, who makes P.O.R. determinations? Only federal quality reviewers, remember they got the special blue suits, can make P.O.R. determinations. An adjudicating component cannot use P.O.R. in deciding whether to request required medical or vocational documentation or as the basis for rebuttal of a cited deficiency. So in other words, the regular system you normally go through to be adjudicated, right? DDS deciding the claim, right? Initial filing and reconsideration, or ALJ is deciding the claim at the hearing level, or the appeals council, AAJ, is deciding the claim all the way at that final stage of the SSA. Those are different adjudicators than the ones we're talking about here. The ones here are their own special federal quality reviewers. Cool. The consideration or application of P.O.R. is solely at the discretion of the federal quality reviewer. So put another way, the federal quality reviewer gets to have a lot of leeway on, do they want to look into this file? Which files do they want to read first inside the file? All that kinds of stuff. Under the P.O.R. policy, if a disability determination is not documented per SSA disability program policy, but the evidence is sufficient for the federal quality reviewer to determine that the missing documentation is unlikely to reverse the disability determination or change the length of the period of disability, the federal quality reviewer may classify the missing documentation as a medical or vocational documentation, TCA, as defined in GN 0440.232A3, and not return the case to the adjudicating component for further development and correction. So the important part there, just to make you guys fully aware of it, it's this part right here. If the evidence is sufficient for the federal quality reviewer to determine that the missing documentation is unlikely to reverse the disability determination or change the length of period of disability, then the federal quality reviewer may classify it as a TCA, and basically, then they move the file along. That's basically what they do. So they have that power to say, you know what, it's missing this, but it's fine. It's still going to render the same decision. It's a little harm, little foul, but it's not going to change it. So they just move the file along. When a case does not contain complete medical documentation per SSA disability program policy, the federal quality reviewer, now here's the important part, must, it's not a may, it's not a maybe, they must. So when it doesn't have enough medical documentation, they must review, send the case to the regional office medical contractor. Medical contractor is the person who reads the documentation. There's also the psychological contractors, the MC and the PCs. The medical contractor is the physical one, like a physical doctor, that handles physical impairments. They read it, give an opinion on it. The psychological contractor is the one who reads the mental claims and gives an opinion on them. So if it's missing medical, they must send it to the MC or the PC and for review prior to making a P.O.R. determination, because the SSA wants to make sure they've got enough medical evidence to stamp it approved, stamp it denied, reverse it this way, or reverse it that way. Cool. The regional office, MC or PC, either indicates the evidence is insufficient to determine the severity of any alleged impairments or prepares a conditional severity rating, usually a residual functional capacity based on the existing evidence in the file. All right, so let me explain this part real quick so that everybody's on board. The regional office, the medical doctors that are just like, consultants that review it and then basically give a summary decision on it, like, hey, we think they have severity here. We think they're pretty bad there. We don't think they're bad enough here. We don't think that they're severe. We think they're moderate here, right? They basically can go ahead and create a severity rating system that turns into your quasi RFC, residual functional capacity form, lifting, pushing, pulling, crouching, kneeling, stooping. It gives you an analysis as to how much they can do these things in a vocational setting based on the existing evidence in the file. So what they're looking for is, if there's not enough medical evidence, they want these medical consultants to basically give a severity analysis: mild, moderate, severe, extreme. Severe is usually called in the medical facility marked, M-A-R-K-E-D, marked, okay? And so the point of it is, the SSA is saying, hey, medical consultants, how severe is this person from what you see in the file? Is there enough medical evidence to actually make an assessment as to severity? Next one. The regional office MC or PC may prepare, remember, may, not a must, but they may prepare a CSR when the medical evidence, so it's conditional severity rating, when the medical evidence in file is insufficient to rate the overall severity of all of the claimant's allegations, but is sufficient to prepare an assessment on the severity of one or more medically determinable impairments. So remember, MDIs are like, your top bullet points for the medically determinable impairments. And then below that and below that and below that are like the ones where we're like, it's an impairment, but it's for the adjudication purposes, it's not really a big item. But the big cookie ones are the MDIs, the medically determinable impairments. And what that equates to, right, is essentially they're saying, hey, look, if you can't tell us what's going on with all the impairments and how bad they are, tell us what's going on with one or two of them where there is enough medical evidence to give us a severity rating via a CSR, which is a conditional severity rating. Okay. I know this is complex. I'm trying to break it down. I got you. All right. Now, with it, I just read Iron 2011 Rob's statement. Walter needs to have a disclosure/warning for wandering minds. For all of my squirrel brains, I love you. I love you dearly. For all the trolls, I'm going to find you a home. I have adoption papers that I'm working on right now. We're going to adopt you to so many other channels. You will be loved by many. All right. With that said, let's keep rocking. So with that said, the regional office MCs and PCs may also offer opinions on the potential effect of missing documentation of impairment severity or RFC. So the medical consultants can be like, hey, we need more medical from this type of doctor. We need an eye doctor. We need a musculoskeletal doctor. We need a cardiac doctor. We need a psychologist, psychiatrist, behavioralist, or whatever. We need this evidence, okay? However, these opinions are not binding on the federal quality reviewer. So in other words, the federal quality reviewer can be like MCs, PCs, you medical consultants, I really like what you had to say, but go bleep off. That's the power of these federal reviewers. So, however, these opinions are not binding on the federal quality reviewer. Federal quality reviewers should exercise caution when using a CSR to support a P.O.R. determination when the disability determination is unfavorable or less than fully favorable, which usually means that they're changing the alleged onset date to give a partially favorable. Stacy, thank you. I love the old NES icon one there. Thank you for the $4.99 donation. That's absolutely amazing. That is a super donation on the live stream. Very, very cool. That actually, so I had my first system in NES was the system that came right before that system. So that's awesome. Now, real quick, note, in an unfavorable or less than fully favorable determination, there is a statutory requirement that adjudicators must consider all evidence available in such individual's case record and must develop a complete medical history of at least the preceding 12 months for any case in which a determination is made that the individual is not under a disability. So here's what they're saying. They are concerned that if the record doesn't have enough medical evidence, that when these medical consultants who haven't seen the actual impaired person, they don't see him, they just write up a report on him. They just look at the evidence that's in the file. They're concerned and they caution this quality control person using the P.O.R. system. They caution them to not be hasty to use this severity system analysis on the limited amount of information that they have. Old School Trucker, thank you for the $5 donation. Love the NES again. That's awesome. Very, very cool. I love that system. I love the original system too. I'm trying to think of which system actually had. I think it was the one that was like more of like a cute. No, it had the rounded. It was one of these systems. I think it was which system had GoldenEye? Boy, I forgot. Gosh, geez. Which system had GoldenEye? Because that was so many hours as a kid. All right, here we go. Next one. Federal quality reviewers must return. It's a must. Remember, they have to. They're required to by law. Return 12-month medical evidence of record (MER), TCAs, which are limited to unfavorable or less than fully favorable determinations, to the adjudicating component for additional development and correction. For additional information, see non-substantive technical corrective action. Let me read it again, then I'll give you the explanation. Federal quality reviewers must return 12-month medical evidence. Okay, so 12-month medical evidence of record, it's in the file, TCAs, okay, which are technical corrective actions, which are limited to unfavorable, so you got denied, or less than fully favorable, you got a partially favorable, which means they're moving the alleged onset date and usually giving you less back pay or retroactive benefits, to the adjudicating component, right, the group that decides claims, for additional development and correction. So in other words, they got to send it off to the people. Oh, this chair's going to break. I got a new chair coming. They're going to send it off to the, oh, this chair's going to break. Oh, it's going to break. They're going to send it off to the more traditional adjudicators to rebuild the claim and turn it into what should have been a proper adjudicated claim to begin with. Okay. So let me just summarize. There's these quality review people. They're special. They use the P.O.R. system to find which files suck a little bit and don't have enough medical or work history or work evidence. They then review it and send it off to a medical consultant and say, what do you think? Where's this person at? Should we just keep passing it through, or do we need to send this off to an adjudicator to actually build the claim and fix the claim? And then if it needs fixing and it needs more evidence, they'll send it off to an adjudicator who will usually send it off to what's called an ME, which is a medical expert. The medical expert is the person where they send you off to go see their doctor. All right, cool. So now you got that summary. Now you get it. Let's keep rocking. Adjudicators and federal quality reviewers are reminded that in some cases, such as those involving traumatic or acute illnesses or injuries, 12 months of evidence may not be available. All right, so let me give you a heads up on this. Sometimes y'all get into a car accident. Sometimes you lick the lava pit. And sometimes, I'm not saying you do this, I'm not trying to be mean, but sometimes you ride motorcycles. And as a result of that, you get injured, it happens, boom, and then you're messed up. Like, it's just not good. You are messed up. Like, if you were trying to see the rockets going up too close, you were like, I want to feel the sunshine. Then at that instance, right, you become one of those, you're broken, you're never going to be, unbroken. So in that instance, they're saying, hey, adjudicators, just keep in mind, some of these people, it is what it is. They're never going to be right again. It is what it is. If the federal quality reviewer determines that the missing documentation is likely to reverse the disability determination or change the length of the period of disability, or if the federal quality reviewer is unable to determine whether the missing documentation may reverse the disability determination or change the length of period of disability, the federal quality reviewer they have to cite a group 1 or group 2 documentation deficiency and return the case to the adjudicating component for further development and correction. So what they're saying here is, look, if this claim is really tricky and confusing and they're not really sure whether or not they've got enough, they're not really sure if it's going in the right direction, they're not really sure where to dig to figure out if this claim's going to actually be easy to just stamp it and move it on, they say, look, just send it over to the people who are going to build it out and then have them build it out more. And that's the whole gig there. Just have them fix it by building it out more. Okay. When to consider or apply P.O.R. Now, for those of you who are just joining us, what we're doing is we're going through the system that they use inside their computer to either remove benefits or give benefits. It's called the P.O.R. And basically, the P.O.R. is the probability of reversal in the quality review process under GN 0444.0.110. All right. When to consider or apply P.O.R. Level of adjudication. Federal quality reviewers may consider or apply P.O.R. to all types of determinations, i.e., fully favorable, less than fully favorable, or unfavorable. For fully favorable determinations, the federal quality reviewer may consider or apply P.O.R. at the initial and reconsideration level. Okay, because usually the judges are going to know when there's not enough evidence at the OHO level, which includes the ALJs and the AAJs, like actual federal judges. So they're saying, look, federal quality reviewers, they may consider or apply P.O.R. to all types of determinations, but for fully favorable determinations, the federal quality reviewer may consider, right? It's not must, or apply P.O.R. at the initial and reconsideration level. So not the higher levels of the SSA adjudication. For less than fully favorable and unfavorable determinations, the federal quality reviewer may consider or apply P.O.R. only at the initial filing level. Why? Why not initial filing and reconsideration? Because usually by the time you've gone through initial filing and reconsideration, they've had more time to add more medical evidence, they've gotten more forms in, they've had more time to build the claim and make the claim into something larger. So to be fair, they don't really need to check it again at recon because they've already had a second shot at the claim again. When the next level of appeal is a hearing, the federal quality reviewer cannot apply P.O.R. because an administrative law judge is required to fully document the case record. So in other words, they're saying ALJs, federal disability judges, are required by law to fully build out the claim. Right. They're lawyers. They've had special training. They're getting special training all the time. They're just a faster, cooler, brighter person that adjudicates these claims. They're a doctorate plus level individual. So inherent in that, they're saying that judge is legally required to build the claim out if it's not built out enough. Okay, next one. If the only reason for returning a case to the adjudicating component is to complete the record in the event of a hearing, the case contains a TCA, not a Group 1 or Group 2 documentation deficiency, and the federal quality reviewer must return the case to the adjudicating component for additional development. All right, so just to be fair, to make it simple, because a lot of people are like, what are all the little caveats, all the little things that work? If the person isn't sure what they need to do with it as a quality review person, and the P.O.R. program says, hey, take a look at this, you might need to pull their benefits. Basically, if they're not sure what to do, they got to send it back to the adjudicators and let them rework it. Okay. Reminder, federal quality reviewers cannot consider or apply P.O.R. to disability determinations originating from the remaining prototype states. Okay, so I'm not going to go into that right now because that's too much in the weeds. Now, with that said, deficiency types. Federal quality reviewers may consider or apply P.O.R. for Group 1 medical documentation deficiency, Group 1 vocational documentation deficiency, which is like work documents, work evidence, Group 1 medical evaluation deficiencies involving vocational documentation. So when they do a medical evaluation deficiency, what they're saying is they had a medical evaluation and it didn't include enough vocational, like could they do work, could they do an RFC analysis stuff in that evidence that was created and provided. Now we go to Group 2. Group 2, onset date documentation deficiency, meaning basically we don't have medical documentation or information about prison time that was served where they were in for more than 30 days. We don't have essentially the proper onset date information that we need to get a proper onset date established as to when their impairment became severe and what other rules might change when we can start their impairment. Because remember, even though you could be medically severe during a particular month, if you're doing other things that violate that law, like for example, you're in jail for more than 30 days, or you're in prison for more than 30 days, or you're at a facility that's paid for federally for more than 30 days, stuff like that, then technically you have to do the month after the last month that you were participating in one of those federally backed programs. Cool. So Group 2, onset date documentation deficiencies, Group 2, ending date documentation deficiencies, Group 2, cessation date documentation deficiencies. You guys know what cessation claims are. Group 2, work activity documentation deficiencies. Work activity is like, were you working? Were you earning over SGA? Do they need to change any of these dates in here because all of a sudden they didn't know you had earnings? It popped on the IRS, new hire query, and all of a sudden the SSA is saying, whoa, something's wrong here. All right. Guidelines for making the P.O.R. determination. Federal quality reviewers should use the following guidelines to make a P.O.R. determination, right? Which is their process for deciding if they're going to yank your benefits or allow you to keep them. Federal quality reviewers must seek input from regional office MCs or PCs. Those are the medical consultants that look at your claim file and then write up a decision as to whether or not they think you're severe enough. Right. So, okay. Federal quality reviewers must seek input from regional office medical consultants if the specific facts of a case require medical review or the federal quality reviewer deems such input beneficial. Now, look, if I was a actual federal quality reviewer, anytime there was any question related to medical, just a CYA, cover my butt, I would send that sucker off to get basically a mental and a physical review from a consultative examination, individual, like a doctor giving me a report summary. Why? It just makes it easier for me, right? If they're giving me a whole report as to medically where this person's at, I'm going to use that. You know what I mean? There's the evidence. Hey, all right. Step one. The federal quality reviewer must thoroughly review the sample case per normal procedures. So, in other words, that's a really big, way of saying, look, you know where to look, you know what files to go to first, you know what information to look up first. Quality reviewer, it's up to you to get through the file and figure out if this is not going to work as a file to give benefits. If the existing medical and vocational documentation is sufficient to support the adjudicating component's determination and is policy compliant, the federal quality reviewer must clear the case as clean and route it to the field office, which is another way of saying we looked over the file, we scrubbed it, looks clean, bubbles are nice. We're shooting this thing over basically to the field office to get it off our list. Now, step two, if the federal quality review of the sample case reveals the existing medical and vocational documentation reasonably appears to support the adjudicating component determination, but the efforts made to obtain documentation are not fully policy compliant, HIPAA violations, the federal quality reviewer may consider P.O.R. Look, so in this instance, what they're talking about is the obtaining of documentation. So let me read it to you again. Appears to support the adjudicating component's determination, but the efforts made to obtain the documentation are not fully policy compliant. So let's say instead of, let's say that they go and buy some records or they obtain some records from the claimant and the claimant is sending stuff in and it might have been the claimant's documents might have been a forgery. They might have been fraudulent. Right. And then they're like, well, maybe we should 827 send out a HIPAA to that facility and just get the documents from them directly. And then they don't do that. This is an example where they have to sit there and think, should we do essentially a P.O.R., assessment, probability of reversal where they snag your benefits. Cool. Step three, the federal quality reviewer must specifically identify what medical or vocational documentation is missing and what policies the adjudicating component failed to follow when developing the documentation. Step three, real simple. You just got to specify what's missing and, kind of what you're looking for. Step four, the federal quality reviewer must determine what level of impairment severity, RFC, and vocational factors would reverse the disability determination or change the length of period of disability. So this is where level four, step four, they've got to do the seesaw effect, right? If the claim had this, it would be an approval. The claim is missing something. If the claim had this, it would be a denial. So they need to go find out what evidence exists. Is it the kind of evidence for this claim that's likely to equate to an approval or the likely evidence that could equate to a denial? Although I think I switched up my arms there. Example, if an unfavorable determination, so they denied the person, is not documented per policy and the claimant is 25 years old with a high school education and has the capacity to perform a full range of sedentary work, the claimant's impairments have to meet a medically equal the listing for the missing documentation to reverse the disability determination. Thus, a TCA would be prudent in this case. God, how would they expect an American doesn't live in this world to read and how would you expect somebody to understand this example? How would you ever expect somebody who doesn't live in this system? Okay, let me explain what this is. And you could do a whole video just on this example. All right. If they deny a 25-year-old who has a high school education and the ability to perform full range of work at the sedentary capacity. Okay. Then your only other options, you can't use a grid out because he's not old enough. Your only other options are compassion allowance listing, right? Which, if you have that impairment, you're found disabled, or a regular listing, which is a big list of impairments that you have to meet, equal, or exceed. You have to be as bad as that listed impairment, equivalent to it, or worse than it, right? So that is what they're saying here is the only other way, and this technically there's more ways than even that, but the only other way is that they'd have to meet, equal, or exceed a listed impairment. You can do a whole video on that one on its own. Example number 2. If an unfavorable determination is not documented per policy. Okay, so if an unfavorable determination, they deny the person, is not documented per policy, something is missing, and the claimant is 56 years old with a 5th grade education, does not retain the capacity for past relevant work. So you couldn't give them a job for the jobs they were doing. You couldn't give them another type of job because of their education level being limited. They don't have any recent education, and they're 56 years old. A moderately severe impairment and certain functional limitations potentially found in the missing documentation are likely to reverse the disability determination. Thus, citing a group 1 documentation deficiency would be prudent in this case. All right, let me spell that out so you understand what's going on. I know that this is tough. I know. All right, so here's the deal, okay? In this example, you have a 56-year-old. They should grid out because they only have 5th grade education, right? They aren't capable of being put back into the work environment with new education that they've received. And basically, they haven't had work within the past 5 years that they can use. As a result, moderately severe impairments mixed with other limitations that are vocational, like you couldn't do certain things, you couldn't lift certain items, you couldn't follow certain steps, that equates to a grid out approval. Some of this I know is too complicated. I totally get it. Some of you will get it. I totally get it. I understand. A lot of this is tough. I know. But it's important for you to learn this system because this is what they file to take back benefits. And that's not a good thing. You want to be educated on this stuff. All right, here we go. Step 5. If the federal quality reviewer, based on disability policy knowledge and quality review case experience, A, surmises that the missing medical or vocational documentation is likely to reverse the determination or change the length of period of disability, the federal quality reviewer must cease consideration of P.O.R., cite the appropriate documentation deficiency on a request for corrective action, document the consideration of P.O.R. on the request for corrective action, and return the case to the adjudicating component for additional development and correction. So bottom line is, if there's too much missing, they got to send it off to get more adjudication from a traditional adjudicator. B, if the person doing this cannot reasonably ascertain whether the missing documentation is likely to reverse the determination or change the length of period of disability, the federal quality reviewer must cease consideration of P.O.R., cite the appropriate documentation deficiency, what the record's missing, on a request for corrective action, document consideration of a P.O.R. on the request for corrective action, and return the case to the adjudicating component for additional development. Put another way, if the person doing a quality check on the claim to potentially pull the benefits, give the benefits, etc., if they feel like there's something missing and they need more, right, in this situation, it's just, there's too much missing, we need more to figure out what we're actually going to do with this, send it back to the adjudicators. C, this is option 3, surmises that the missing medical or vocational documentation is unlikely to reverse the determination or change the length of the period of disability, the federal quality reviewer must document application of P.O.R. using a case note. And with this one, the bottom line is they're just going to go ahead and say, hey, it's not going to change anything. Just move the case along. Don't waste time on it. All right. Documenting application consideration of P.O.R. We're going to catch up with that one a little bit farther down the line because we're at 34 minutes. I hope you are starting to appreciate from this that you understand all the systems that they use to potentially remove benefits. And the reason why this is so crucial is that if you understand the steps that they use progressively through this process to create a likely situation to either let you keep your benefits or remove them, and you understand what type of logic they use throughout it, then you're going to be doing better to keep your benefits for a longer period of time. And here's why this matters. Let's say, okay, that you send in evidence to the SSA and the evidence looks like crap, right? It's like the page is all skewed and manipulated and the page is all squishy and yada, yada, yada. And then they make a decision based off of that piece of paper that looks like it could have been modified. Well, you could end up in a P.O.R. assessment with a quality review person saying, hey, this evidence potentially is not quality evidence. And then they have to send out to get the evidence directly. So always make sure that the submissions you make are clean submissions that look proper. And, remember at the end of the day, you might be sending in a document where you're the only one who has a copy of it. Sometimes you have claims where you have to prove something and it's like 10 years back and you're the only one that has a copy of it because everybody else that was supposed to be a custodian of the record, they're allowed to, by federal law, destroy it after a certain amount of time and you were past that time. So just make sure clean copies submitted. Okay. All right. With that said, we've covered a lot of stuff in this. I'm going to do the deficiency notifications of class 1 and 2 on another video. And then we're also going to be basically going through when the P.O.R. is directly applied for documentation, application, and consideration. So we'll do that in another video. With that said, the next video I'm going to go live and answer questions for free. You know how it works. So I will see you at that video. Please remember to hit that like button. Don't be afraid to hit it. Give it a little touch right there. A little like. With that said, I will catch you at the next video where I answer questions for free. Give me about 5, 10, maybe 15. Give me about 5, 10 minutes. We should be good to go. I go live on Mondays and Thursdays usually. Sometimes I fall asleep, so I don't get to do it because I work at the law firm the entire week, including Saturday and Sunday. And bottom line is, if you want to go ahead and have a private session, that's one of those 1-hour private sessions with the mini contract below in the bio area. You can hire me for 1 hour to figure something out, to fix something with your situation. Or honestly, run hearing questions, figure out what you should be doing about the CDI unit that's investigating you. You're transitioning into disability, want to know how to transition from your job to that, all that kinds of stuff. I will catch you a little bit later. You have a wonderful, wonderful day, and I will see you at the next video shortly. Thank you so much. Have fun, and I will see you there soon. Thank you so much. Bye-bye, everybody. Bye-bye.